Hi, I'm Ken Lammers. Welcome to this week's Cltv. And today's subject is going to be whether or not prosecutors or defense attorneys are better at playing the objection game during a jury trial.
The number you have reached, 911, has been changed to a non-published number.
Hi again, Ken Lammers here. What brought this subject to my mind is that over at the Matlock blog, Sean Matlock wrote a blog posting in which he asserts that defense counsel are better at playing the objection game, strategically objecting, than prosecutors are. And how prosecutors don't think 3 steps ahead, and they don't think about how it affects the jury, and all this sorts of thing. I disagree with that. Now let me say this. Now, generally, this is something that I think that Sean Matlock is mistaking inexperience for prosecution. That's the only thing I can think of. Because this is something that can fall on both sides. Inexperienced defense counsel will do exactly the same things he's talking about. Make legalistic objections, hearsay, best evidence, all these sorts of things which aren't really helpful to the case, but are technically correct, and which make the jury eventually get tired of you or think you're hiding something. And inexperienced attorneys on both sides will do this sort of thing. I don't think that experienced attorneys in prosecutors' offices are any worse at this than experienced defense attorneys are. I think both sides think ahead as to what's going on. Now, there are certain differences. Now, I will say this. Now, and this may just apply really in Virginia. I'm not so sure about other states. But, for instance, in Virginia, because our appellate courts absolutely require, that there be a record made with an objection stated and reasons given, defense counsel have an obligation to make objections. On the other hand, once trial started, prosecutors know full doggone well that making an objection isn't going to do them any good unless it's an objection that actually helps the case. Because they ain't going to get to appeal the case after it's all said and done. It's either going to be guilty or not guilty. So there's no reason to make an objection knowing the judge is going to shoot you down, with exception, like I said, of possible strategic reasons. Now, what objections might you see in court that are going to be strategic? A strategy that I've seen employed by a number of prosecutors has been the I trust the citizens of my county, the citizens of my city strategy. Prosecutors who don't ask a whole lot of questions during voir dire, but make it very clear as they walk up there, Judge, I really don't see a whole lot of reason to ask questions because every citizen of Pitcairn County is qualified and capable of doing their duty as citizens. Say something like that as they walk up, as a throwaway to explain to the judge why you're only going to ask like 2 questions. Furthermore, during case, make a half-hearted objection and go, no, Judge, I'm going to withdraw that objection because, I don't think it's relevant, but I'm not going to. The jury should see everything so they've got no doubt in their mind. Statements like that, which tend to be the "we're all in this together" statements, might be a strategic thing that the prosecutor does with the jurors. On the other hand, the defense counsel might make objections angled to make the prosecutor look like he's doing something unfair, or that he might push something, trying to get to a point where it makes the prosecutor look like he's hiding something. And you got to agree with Sean here that when objections are made, generally by either side, there's something that's being hidden, usually for good reasons that we've made, policy-wise years ago, but that there's something that's not being allowed in. Whether it is, a triple hearsay, Bob said that Mary said that she heard Joe say, something like that, which is incredibly, uncheckable. You can't cross-examine that, no matter what anybody says. So we are trying to keep stuff like that out, and other things along, defense or prosecutor maybe, make that motion and eliminate ahead of time, or maybe during trial if he didn't catch it ahead of time, keep the witch doctor out because what he's going to say doesn't follow any real medical field or evidence or something, and his testimony as to the evil spirits possessing John Smith and making him do this really isn't something that we allow in our court of law. The prosecutor would probably object pretty vehemently to try to keep that out. So you get those sorts of situations. Now what's really interesting is watching some truly experienced attorneys, defense counsel and prosecutor, who aren't making many objections, who are kind of both sides playing strategy with the jury. I'm not hiding anything. No, I'm hiding less. No, I'm hiding less. That sort of thing. You can end up with some cases where there's not a whole lot of objections, particularly in fact-specific cases, where you've got 4 fact witnesses here, 4 fact witnesses here. It's about a fight, and there's not a whole lot of any legal issues here because the law is completely settled. So in those sort of cases, you may not hear an objection from either side if they know what they're doing. Although in those sort of cases, which are usually driven by the citizens, there's going to be all sorts of hearsay and all sorts of stuff that you could move to exclude on relevancy grounds. But you may not hear a single objection from either defense counsel or prosecutor, because neither side wants to play that game where they look like they're hiding something, or where people, sometimes when you object in those sorts of cases, they go off and just kind of go nuts. But, so you can end up with that sort of thing where well-practiced attorneys don't do a whole lot of objections. And on top of which, well-practiced attorneys know, as part of the game, that if they do an objection and it's piddly, that well-practiced attorney on the other side is going to probably turn that and make them look silly. And so they don't play the games. It's kind of a mutually assured destruction situation. And as to Sean's last question, how far ahead, how many steps ahead does a prosecutor think? Well, I don't know how many steps ahead I think. I do know that I'm thinking at the end of the trial how this is going to turn out. And I'm thinking of shepherding the case along the direction I want it to go. Now, I'm not thinking 3 steps chess-wise. If I move the queen here, will I'll be able to take the knight in 4 moves. I'm thinking, this issue here, how is it going to play in closing argument? And I think most serious and qualified prosecutors are thinking that way. You make your opening statement, but you play for your closing statement. And you try to shepherd everything in a particular direction towards that closing statement and towards that conviction. And if you want to state that as thinking steps ahead, well, it probably depends on how many witnesses you got. It may be 4, 5, 6 steps ahead, but it is thinking ahead. It's thinking towards the end of the trial. And I think any capable attorney does that, whether it be a prosecutor or a defense attorney. Now, whether or not being a prosecutor qualifies you to be a defense attorney right off the bat, or vice versa, I don't think it does, because I think when you flip, having some experience in this, when you flip from one to the other, your basic knowledge of the law is pretty strong, but there are some tactical differences that you need to learn. For instance, when you go from, I was what I called a laser beam defense attorney. I focused in on what was wrong with the prosecutor's case and I cracked it if I could. Well, you don't do that as a prosecutor. You can't do that as a prosecutor, because you have to do the piddly stuff, which the technical stuff, which the defense counsel will move to strike over if you don't do it. So you have to say, Officer Smith, can you identify for me Mr. Green in this courtroom? And he points to the person sitting next to the defense counsel. Officer Smith, in what county, city, state did this occur? Well, it happened in Pitcairn County in the state of Virginia. Yeah. Now, you get strange looks from the jury who are going, what? And half the time the officer's just kind of going, okay, why? But if you don't, there's going to be a certain percentage of defense attorneys who are going to stand up and go, Judge, I moved to strike. He never proved that it happened in Pitcairn County. Yeah, well, we're in a courtroom in Pitcairn County. The officers from Pitcairn County, all the witnesses are from a store that's on Main Street in the middle of Pitcairn Town in Pitcairn County. I kind of think maybe perchance it was in Pitcairn County, but you have to prove it, so you have to ask that question. So that is something you do have to learn, little differences like that when you move from one side to the other. I'm not sure what exactly somebody moving from a prosecutor to the defense side has to learn per se, exactly. But somebody else who's out there might fill in a comment to tell us what that would be. And ladies and gentlemen, I think I've spoken long enough, kept your ears busy, and until next time, have a good week.